This is part 5 of constitutional law, looking at freedom of expression and association, where the government seeks to regulate speech, and that speech is expressive conduct. Expressive conduct may be regulated if it's within the government's police power to enact the regulation. The regulation furthers an important government interest, and it is unrelated to the suppression of ideas. And the burdens on speech are no greater than necessary. Examples of permissible regulations of expressive conduct include banning public nudity. Impermissible examples of regulation of speech involving expressive conduct are where students wear black armbands, a ban on burning a flag, ban on leafleting that results in littering. Here the interest, where the government argues there is an interest in clean streets, this is an insufficient justification. Again, freedom of expression and association, the regulation of speech, and overbreadth of the regulation. Overbreadth is where the regulation burdens substantially more speech than is necessary to protect a compelling government interest. Now, this may be challenged as facially invalid to prevent a chilling effect on protected speech. Examples of overbreadth are banning all First Amendment activities in an airport terminal, or an ordinance requiring a permit to engage in door-to-door canvassing and or solicitation. Freedom of expression and association, regulation of speech, and vagueness. A regulation may be void for failing to provide persons of an ordinary intelligence fair notice of what is prohibited. Examples include indecent speech, what speech is indecent, and or annoying conduct, what conduct is annoying. Continuing with freedom of expression and association, regulation of speech, and prior restraints. Prior restraints is a regulation of speech that occurs in advance of the speech and or expression. Now, with limited exception, this is generally presumed unconstitutional. The burden is on the government to prove the material to be censored is not protected speech. Exceptions where prior restraint may be valid is where there is a particular harm to be avoided, such as publication of troop movements. Another exception where prior restraint may be valid is where procedural safeguards are provided to the speaker. These standards are narrowly drawn. A censoring body promptly seeks injunction. So a regulating body must promptly seek an injunction on the speech. Example of invalid prior restraint is for national security, such as the Pentagon Papers or press coverage of a trial. Freedom of expression and association, regulation of speech, and the freedom not to speak. Generally, we know that we have a freedom not to speak. The government cannot force private organizers of a parade, this is an example, to include a group whose message organizers disagree with. That's from Hurley. This is where organizers of a parade, I believe in Boston, refused to let a GLBT float in the parade. The GLBT people sued, and the government said, that's okay, you don't have to be allowed in. So the government cannot force private organizers of a parade to include that group whose message the organizers disagree with. Now, you cannot make a condition of federal funding that recipients explicitly agree with a government policy to oppose prostitution and or sex trafficking. That's from Agency for International Development. You can compel a mall to permit individuals to exercise their own free speech rights when the mall is open to the public, which a mall generally is, and the message is not likely to be attributed to the private entity, to the mall. That's from Pruneyard. We got freedom of expression and association, regulation of speech, and government speech. Government speech is not constrained by the First Amendment. Government speech need not be viewpoint neutral. However, government speech is subject to the Establishment Clause. And that completes Part 5 of Constitutional Law.